If you or your family member or a loved one has ever been arrested for assaulting a public servant, you could be staring down a felony conviction in Oklahoma. Maybe it happened during a heated argument with a cop, or things got out of hand at the jail. But now you're being treated like a violent criminal. And if you don't handle the case correctly, you could lose your job, your gun rights, and even your freedom. I'm John Cannon, criminal defense attorney and former prosecutor based here in Oklahoma, and I've helped dozens of clients walk away from cases just like this. In this video, I'll break down the exact legal strategies that could get your charges reduced or even dismissed, so you know what to expect, what mistakes to avoid, and how to protect your future from one bad night. Number 1. What counts as assault on a public servant in Oklahoma? Let's get right to it. In Oklahoma, the law treats any physical contact or threat against a public servant very seriously. Now, who is a public servant? That includes police officers, EMTs, firefighters, correction officers, teachers. Basically, anyone working for the government while they're on duty. You don't have to throw a punch or cause an injury to get charged. Even a shove, a spit, or a thrown object can land you with an assault on a public servant charge. For example, I've seen clients charged because they were involved in a heated argument with a police officer and ended up bumping them, or because tempers flared during arrest and they swung their arm while being handcuffed. The bottom line, if a public servant claims you intentionally touched, hit, or threatened them, there's a good chance you'll be facing felony criminal charges under Oklahoma law. But here's the thing, just because you're charged doesn't mean you're guilty. The law has specific rules the state has to prove before you can be convicted. Understanding these details is the first step to beating your case. If you're watching this because you or someone you love is facing this charge, the prosecutor has to prove 4 main things, and they have to do it beyond a reasonable doubt. That is a high standard. If they can't check off every box, you should not be convicted. Here's what they need in Oklahoma. First, they need to show there was an intentional unlawful attempt to cause harm or actual harm or offensive contact. Accidents don't count. They must prove intent. Let's say you're handcuffed in the back of a patrol car and you move suddenly without meaning to hit anyone. That's not supposed to be enough. The state must prove there was pain experienced by the officer. This doesn't mean it requires proof of bruising or injury, but if the cop was merely offended by what you did, that is not enough to charge with assault on a public officer in Oklahoma. Second, the prosecution must prove that the person you allegedly assaulted was indeed a public servant. That means their job status matters. Sometimes it's not as obvious as you think. We've seen cases where a plainclothes officer didn't identify themselves properly, or where a school official wasn't performing their regular duties at the time. Third, the alleged assault has to occur while the public servant is performing their official duties, or because of something they did in their job. If you get into a scuffle with an off-duty corrections officer at the grocery store over parking space, that's not enough. Fourth, the state must prove you knew or reasonably should have known that the person was a public servant. If you have no way of knowing who they are or what they're doing, that's a potential defense. If even one of these elements is missing or unsupported, your case can fall apart in court. That's why it's so important to have an attorney who can spot the weaknesses in the government's case. One of the most common ways to beat an assault on a public servant charge is by showing you acted in self-defense. Here's what you need to know. In Oklahoma, you have the right to defend yourself against unlawful force. Yes, even from a police officer or another public servant. Of course, this doesn't mean you can fight back just because you're scared or angry. The law is clear. If a public servant uses more force than is reasonably necessary, or if they act outside their legal authority, you have the right to protect yourself from serious harm. Let me give you an example. Let's say Tom is being arrested for a minor traffic violation. The officer got aggressive, twisted Tom's arm behind his back, and shoved him face down on the pavement. Tom struggled not to escape but to breathe and avoid injury. The officer later claimed Tom assaulted him. But here's what Tom can do in that circumstance. He can work with his attorney to pull body cam footage that can show the officer's actions. They can demonstrate that Tom was just trying to protect himself from unnecessary harm. So if you acted to protect yourself and you can show it, you have a strong defense. The key is to gather evidence, like witness statements or videos, as soon as possible. Lack of intent. Did you really mean to do it? Remember, assault on a public servant requires intent. People get worked up during chaotic situations, especially when they're scared or confused. Maybe you accidentally elbowed an officer while being handcuffed, or maybe you tripped and fell into a school official during a tense school board meeting. Intent is a big deal in Oklahoma criminal cases. If you didn't mean to touch, hit, or threaten the public servant, your attorney can fight to get the charges dropped or reduced. I've had cases dismissed when we could show, often with security footage or eyewitness statements, that my client's actions were accidents, not crimes. For example, a client at a hospital was being restrained by security and accidentally kicked a nurse. The DA wanted to press felony charges and did, but we had a competency evaluation done which showed the person was borderline mentally incompetent, and the prosecution agreed to dismiss the case once our client completed treatment for mental health. If there's any chance your actions were accidental, tell your lawyer right away. The sooner you document your side, the better chance you have at beating the charge. You'd be surprised how often these cases come down to the he said, she said. Maybe you're in a crowded bar, a chaotic hospital wing, or a rowdy protest. Sometimes the public servant doesn't really know who made the first contact, or they name the wrong person in their report. In Oklahoma courtrooms, the prosecution still has to prove it was you beyond a reasonable doubt. We can attack weak or unreliable evidence in a few ways. If there's security footage, dash cam, body cam, or even a cell phone clip, we scour it for proof. Does it clearly show you making contact, or does it raise more questions? People's memory is not perfect, especially in stressful or chaotic situations. We dig into what witnesses actually saw and whether their story lines up with the evidence. Even public servants sometimes get facts wrong, or their reports are incomplete. We check every line for inconsistencies. Let's talk about reality. Sometimes public servants exaggerate or misunderstand what truly happened. Emotions run high, especially during protests, domestic disputes, or any heated situation. I've defended more clients than I can count who ended up charged with assault just because they argued, pulled their arms away, or got mouthy. Oklahoma prosecutors sometimes overcharge based on bad information from law enforcement. For you, that's terrifying. But with a strong lawyer, it can actually work in your favor. If your attorney can prove the case is not what it appeared to be when the prosecutors filed your charges, your attorney can negotiate for dismissal or much lower charge. We once had a case where a client was charged with a felony assault on a police officer after a bar fight. When we dug into the evidence, we showed my client never touched the officer, and another person in the bar had actually hit him. The charges were dropped completely. The lesson: never assume you're stuck just because you're arrested or charged. The facts matter. A good defense attorney can pull apart the state's story and show the prosecutor, the judge, or even a jury what really happened. If you're accused of assaulting a public servant, don't try to handle this alone. Here's what a skilled Oklahoma criminal defense lawyer does, step by step. 1. Investigate quickly. We gather every bit of evidence right away. Videos, records, witness names, photos of injuries or lack thereof, and much more. 2. Challenge the state's story. We look for missing details, exaggerations, or flat-out mistakes in the official report or the witness statements. 3. Protect your rights. If you are questioned without a lawyer or pressured into talking, we challenge those statements in court. 4. Negotiate hard. We push prosecutors to drop or reduce charges if the facts aren't there to support the case. 5. Take it to trial. If needed, we will fight your case in front of a jury, and we tell your story in a way the jury can understand and believe. Every case is different, so don't wait. The sooner you have a real defense, the better your odds. Assault on a public servant in Oklahoma is usually charged as a felony. That means real jail time, heavy fines, and a permanent record that can follow you forever. You could lose your job, your right to own a gun, even your right to vote. But if you act quickly, protect your rights, and bring in the right legal help, you give yourself the best shot at beating the charge or getting it reduced. Are you ready for help? Today, we talked about exactly what counts as assault on a public servant under Oklahoma law, what the state has to prove, how self-defense and lack of intent work as a defense, why mistaken identity and overcharging happens so often, and what a good attorney can bring to the table for you. But if your charge goes away or you beat your case, what about your record? That's a whole new fight. So if you want to know how to race your criminal case, And get a fresh start? Don't miss our next video, Expungement, the quick way to erase your criminal record. It's a must-watch if you want your past to stay in the past and protect your future. I'll see you there.